Ladies and gentlemen, welcome to the National Constitution Center. It is so great to see all of you. I am Jeff Rosen, the president of this wonderful institution. The National Constitution Center, as one or two of you may be aware, is the only institution in America chartered by Congress to disseminate information about the U.S. Constitution on a nonpartisan basis. Beautiful. I heard some chiming in. And now we have a second beat on that inspiring mission statement. We're the only place in these polarized times that brings together all Americans to learn about, celebrate, and debate the greatest vision of human freedom in history, the U.S. Constitution. How's that? That's very inspiring as well. Good. Well, we have a superb program today about a topic that could not be more timely, how presidents interpret the Constitution. And before introducing our wonderful author and magnificent moderator, I'm going to put in some plugs for the town hall programs on the horizon. We have just launched a national town hall debate series. It launched at the National Press Club in DC a few weeks ago with the topic, Was the Hobby Lobby Case Wrongly Decided? It is co-hosted by the Federalist Society and the American Constitution Society, these two great lawyers groups from all sides of the spectrum. The next debate is in Boston on May 12th. The topic is the Citizens United case, then New York in June, and we're going across the country. We think that, like the Lincoln-Douglas debates, these wonderful discussions have the potential to transform constitutional discourse as models of civil dialogue. There's another great debate coming up on June 2nd here at the Constitution Center with our good friends at Intelligence Squared. We're debating the question, resolved, the Constitution does not require the states to recognize same-sex marriage. And that's going to be decided just weeks before the U.S. Supreme Court decides that crucial question. It'll be in conjunction with the opening of our new exhibit, Speaking Out for Equality, the Constitution, Gay Rights, and the Courts, which I think is the first exhibit in the country about the constitutional evolution of gay rights in the courts. It's just going to be thrilling, and I can't wait to welcome you here. And then finally, just a series of great events coming up, including on May 4th, Akhil Amar, who will be here to discuss his new book, The Law of the Land. So that's it. Come here early and often, and just, it's a constitutional feast. There's so much on the horizon. Now, it's my great pleasure to welcome Harold Bruff and Peter Spiro, and you are in for a treat because these two scholars are as good as they come. Hal Bruff was Dean of the University of Colorado Law School from 1996 to 2003. He served on the law faculties of Arizona State University, the University of Texas, and GW Law School, where he left the year before I came. So we just missed each other, but I'm so glad finally to meet you, Hal, in person. I've admired your work for so long, and it's so great to welcome you here to the center. He has been a senior attorney and advisor at the Office of Legal Counsel in the U.S. Department of Justice. You know the OLC that provides constitutional advice to the president, the most important constitutional body in the Justice Department. He's testified before Congress on many occasions, and he's here today to discuss his new book, Untrodden Ground. And as our moderator, it's a thrill to welcome my old friend, Peter Spiro. He is the Charles Weiner Chair in International Law at Temple University's Beasley School of Law. Before joining Temple, he was Rusk Professor at the University of Georgia Law School. He is a former law clerk to David Souter. He specializes in international immigration and constitutional law and is the author of Beyond Citizenship, American Identity After Globalization. Please join me in welcoming Hal Bruff and Peter Spiro. Take it away, guys.
So thanks, Jeff, very much for that gracious introduction. It's really a thrill to have Jeff here in Philadelphia doing so many wonderful things at the National Constitution Center. It really is a huge asset to Philadelphia. And thanks also to all of you for coming today. And it's really a delight and a pleasure to engage my old friend Hal Bruff in a conversation about his a very excellent book, which is a real tour de force. I should mention before I forget that Hal will be doing a book signing downstairs after our conversation. But Hal and I go way back, and I feel like he was a mentor to me when I was starting out studying the things that he is one of the real leaders in constitutional law in the field. So we're going to have a conversation, and then I'll prompt Hal with some questions, and then we'll take some questions from the audience, and so looking forward to a really terrific hour here with you. So the first question for Hal really is, for you is why you wrote this book. I mean, the conventional understanding of constitutional law is that it's the responsibility of the courts to tell us what the law is. So what room is there to talk about presidents in their interpretation of the Constitution?
Thanks, Peter, and thanks, Jeff, for the gracious introduction, and thank you all for coming. No audience, no talk, and no book sales. Jeff was talking about the Supreme Court. It's enough of that, okay? We're not going to talk about the Supreme Court in here this hour. If you have a system of 3 separated branches, each of them will interpret the Constitution for itself every day. I knew that for years working on these issues. What struck me about executive interpretation as I went along is that at the end of the day, no matter how many lawyers there were advising presidents, the way presidents interpret the Constitution is very personal to them. It flows out of their personality, their political values, the events of the day, and it proceeds really from their overall view of the Constitution and works down from that toward particular issues. So what really matters in presidential interpretation of the Constitution is the president himself or herself, and that's what drives it. The book is about that.
So, so the book goes through the sort of full horizon of American history and how each of the presidents approached constitutional interpretation. What role does personality play in constitutional interpretation? And can you give us some examples? And in particular, is there a difference between being a good president generally and being a good president constitutionally speaking, or are the two coextensive?
I think there's a very great deal of overlap between being a good president and being a good presidential constitutional interpreter, largely because when you reach this level, the boundary between politics and law becomes indistinct. And what the greatest presidents have done is to reconstitute American politics, and with it they have hauled our views of the Constitution along. Jefferson did that, Jackson did that, Lincoln, FDR, Reagan. So presidential political action eventuates in constitutional change. And that means that the ones who've been effective at the one have been effective at the other. And those who haven't been effective as presidents, generally as we would grade them, have typically had only low impact on constitutional law. Some from time to time, but not as much.
So is there a difference between law and politics, or how? So the line isn't as distinct as you have with judicial institutions, but are there some things that where the presidents are clearly engaging in constitutional interpretation and other areas where it's just politics, and how do the two sort of intersect?
I think at the boundaries it's pretty clear. Some things are ordinary daily politics and some things are technical constitutional interpretation. What presidents do as they look at the Constitution is they are very interested in what their predecessors have done. Those are the only people who have ever sat in that seat. More interested in that many times than what the Supreme Court has said. They want to fit themselves into the tradition. This means that when presidents interpret the Constitution, for lawyers in the room, it's like generation of the common law. That is, custom starts to build, precedent starts to build. And pretty soon we start thinking, this is no longer just a custom, it's constitutional law. An example well known to Peter, because you do international law, is that early presidents started the precedent of deciding who is the correct government of a foreign power. There's nothing in the Constitution on this. So when we recognize a new government after a revolution somewhere, that's a presidential action because George Washington started doing that, and presidents have occupied that constitutional ground.
And you have other fascinating examples. Some of them are historically prominent, I guess, when it comes to issues such as the war power and other national security questions. Others are are non-obvious, I guess, but very interesting demonstrations of the role that presidents play in constitutional interpretation. So issues relating to presidential succession, the veto power, the power to appoint and remove executive branch officials. So these are fascinating examples, even though they're not this sort of headliner stuff.
Let me mention a couple of them. Presidential succession. When the first president to die in office did, William Henry Harrison, John Tyler came in and he took the oath of office. The question was he acting president or was he president? Well, if you're acting anything, you don't have much power. So Tyler said, the Constitution doesn't say, so I'm the president. He took the oath. He started receiving foreign diplomats. He made Congress and the executive branch believe him. And now he just insisted, basically. And now everybody thinks that if the president dies, the next person is president right then. They have to take the oath. So that's a precedent that stuck. There's many others. What was the second one you mentioned?
The veto power?
Oh, the veto power. The early presidents, the founding generation that you see all around this national park, thought the veto should be used only for statutes that were bills that were clearly unconstitutional. Andy Jackson came in and said, no, I'll veto anything I don't like. And famously, of course, he vetoed the bill to reconstitute the National Bank. He made that stick. And here's the conjunction of law and politics. He was democratizing the country in a lot of ways, and having a presidential veto that could override, could stop Congress for political reasons was a real empowerment of the president. That view of the veto is the one we have today. The president can veto a bill for any reason he or she cares to. So there again, it's simply a change in practice that has hardened into constitutional law over the years.
And then with respect to the appointment and removal of executive branch officials, I know at the founding there was a question about whether the Attorney General was going to be really on the president's side, or whether he was going to occupy some sort of intermediate space between the presidency and the legislative branch.
And George Washington decided how that should be done. The statute creating the Attorney General is the one that created the Supreme Court, the Judiciary Act. It simply said there shall be appointed an Attorney General. It didn't say who would do it. And Washington said, that would be me. So he appointed his personal attorney, Edmund Randolph, and many presidents have done that, appointed close friends. And the Attorney General then moved close to the president because of this practice of Washington's. And the Attorney General has been at the president's side ever since. And this means that a president gets sympathetic legal advice from somebody who, as Peter mentions, could have been a kind of a semi-autonomous judge within the executive branch sort of thing. You know what would have happened? Presidents would have found somebody else to ask if that had happened, I think.
I mean, some of these things, from our perspective, it looks like, well, that's the way it just has to be. And so I guess the precedent seems to line up with what makes sense, even though I guess what you're showing here is that it didn't necessarily have to end up that way. Are there precedents are there episodes in which presidents have tried to establish precedents that didn't stick, and are there some practices that maybe don't make sense or have had to be circumvented through other practices?
The most famous example ever of a practice that didn't stick is, of course, the court-packing attempt by FDR in 1937 when he lost his political bearings for the only real time, I think, in his presidential career. There's one that demonstrates one of the real checks on presidential interpretation. He thought he could really transform the Supreme Court in short order. Congress, both parties rose up against it. The people didn't like it either. Subsequent presidents have not thought that's a road they could go down, but earlier presidents had routinely added a justice here or there, or subtracted one to the Supreme Court. It's a practice that ended with FDR's mistake. So overreaching, I think, is the is the sin to be avoided there.
And so if just taking the proposition on its face that presidents can engage in constitutional interpretation does raise the question of, well, what does constrain them in the way that they interpret the Constitution? It's not just something that they can do unilaterally. So what are some of the mechanisms by which they're brought into check?
It's really a question of anticipated reaction. That is, presidents will have preferred interpretations they would like to take and run with. And if they have any sense, and most of them do, they are thinking carefully about what reactions will be in Congress, in the courts, if it's the kind of issue that the courts will take on, among the people. And it's that political construct that also constrains constitutional development. And I think in a way that's very good news for all of us, because the whole system is moving along in this precedential and reactive way. And it's a way that we update our Constitution. We can't really amend it with any ease. It takes 3/4 of the states, and that's almost impossible. That's one reason why the Supreme Court is so active. They've glossed the Constitution deeply, because you can't change the text almost ever. You need some kind of bipartisan thing like should 18-year-olds vote.
And that points to your rejection of originalist approaches to the Constitution. So there are many who believe that all we need to get our constitutional answers is the text of the Constitution itself, and implicitly and explicitly you reject that method of constitutional interpretation. Maybe you could elaborate on that.
I guess I do, although after this talk I'm going to go down and get among the statues of the framers and see if they'll...
The oracle of...
Hoping they'll whisper to me. Sometimes I think I can hear them anyway, but one of the things that both Madison and Hamilton said in the Federalist Papers is, to see how this new construct we've made is going to work, we have to work it for a while. We have to run the machine. And then we'll know how it works out. So they thought that we'd have to adapt to this thing they'd built that they could only imperfectly predict. And generally teaching constitutional law, I don't like originalism because I don't think we can go back. And I will tell you what my book, I think, demonstrates beyond all doubt, is that presidents are not originalists. They, when they can, will cite the framers and so on. Again, they're very interested in their predecessors in office who are post-original. They're interested in what it's becoming, what it's become, and they use mostly strategically things that were said at the founding. Although some, Lincoln did a lot of this, will reach right past it to the Declaration of Independence. Lincoln did that because there were such defects in the original Constitution, which he was having a civil war over. And he wanted to go back to the original founding values of liberty and equality. And presidents who reconstruct American politics and affect the Constitution very often reach back, way back, to what they sell to the people as original values. Ronald Reagan is probably the most recent president who's done that really effectively. Again, they look back to basic values, but not technical originalism.
So there's a kind of moral perspective that comes into play here, or is it a story of continuity and legitimation that presidents turn to in basically selling what they're doing today, or in justifying what they're doing today?
Yes, and I think that Teddy Roosevelt's bully pulpit notion is somewhere near the heart of that, but kind of undersells it in the sense that I don't think the moral dimension of the office can ever be separated from it in terms both of general effectiveness and of constitutional development. I think of both Lincoln with his greatness in bringing the country to a new birth of freedom, and to the presidents before and after who lacked any kind of moral vision that would attract us, because they both saw the country as it had been in 1840 and wanted in many ways to head there. So vision for the United States that looks back for its basic values and forward to what the country is supposed to be. I think that's what's effective. That plus some pragmatism on means. I think a president, to be effective as an interpreter and as a political president, has to be willing to find a way through.
And so maybe we can name some names so that best presidents from this perspective, and maybe those who were some that were more flawed, and examples of how their interpretation of the Constitution didn't fly or was misdirected in particular ways.
As I researched this book, what I wanted to do was to look back at the history. I did that start to end. It took a long time. Instead of imposing a theory on the history. So as I went along, some people surprised me. I had revered Lincoln, and this only deepened because I saw his qualities such as what I call fact hungriness. He always wanted to follow the facts on the ground. Presidents who lose touch with those become far less effective. I think a great difficulty George W. Bush had is he wasn't as interested in the facts on the ground in, say, the Middle East as he should have been. So that fact hungriness matters a lot. Rigidity in means, Woodrow Wilson, I think, lost a lot of effectiveness because he just did not have the kind of subtlety about working his program through that a Lincoln had superbly, that a Ronald Reagan did well. So it's along these kinds of lines that they develop. I wound up liking Wilson a good bit less than I thought I would. I wound up admiring Lyndon Johnson for his domestic side greatly. He brought the civil rights bills through knowing it was going to impact his party for foreseeable future. I think it was the right thing to do. His tragedy in Vietnam wrecked his reputation, but there's a side of it that should still be alive.
So Lincoln, he may have been very careful with the facts, but he was also, of course, somebody who could put expository eloquence to work. And I found very interesting a phrase that you use, that he used with respect to this kind of practice, precedential, this continuity to the founders, the mystic chords of memory, which I thought was a very powerful encapsulation of what you're talking about here. At the same time that you also have a label for this interpretation by the presidents of departmentalism. And so I wonder if you could sort of elaborate on those two strands and maybe what they reflect in the history.
Departmentalism is a term I would never use in the book unless everybody else was already using it, so I had to use it. All it means is the phenomenon that each of the three branches interprets the Constitution in its own way, reflecting its own functions. Obviously, the courts are different from the executive branch. Departmentalism, so each of the three branches looks at it differently. So I thread that through because, of course, I'm looking at one of these threads. The mystic chords of memory is, I think, intrinsic to the way the executive branch does it because you have a string of single individuals at the apex who can try to relate in as systematic a fashion as their values and politics will allow to everything that's gone before. And what strikes me very much about reading about all the presidents, everybody down through Barack Obama is like this, is they are forever talking about what their predecessors have done. They are deeply interested, all of them, in their historical legacy, and they try to connect it up to, of course, the grander figures of the past. Nobody is looking to be the next Buchanan, all right?
Fair enough.
But those are the connectors, and some of them really are mystic because they're in values and visions for the country, that kind of thing.
So maybe bringing the story up closer to the present day, how would you compare the personalities, the styles of George W. Bush and Barack Obama in terms of their their approach to constitutional interpretation, and which of their predecessors do they most resemble in their constitutional style?
So how are they like and unlike each other, and who are they like and unlike? Okay. To start with Barack Obama, I think the highest compliment I can give him, the one he'd like most, is that I do consider him to be fact-hungry, like Lincoln. This was a problem for George W. Bush, I think, who was less so, much more value-based. Both of them have had difficulties that come from parts of the package that aren't there. For Barack Obama, somebody who had read the book once said to me very cautiously, it looks to me, frankly, as though maybe he's a bit too much of a professor. And so I said, that's exactly right. That's the problem. He's too much of a professor. He's forever explaining things the way I might, and not the way, say, Ronald Reagan would. So I think for Obama, he hasn't had as much of an overarching vision as the reconstructive presidents have. I think modern politics have made that very difficult in ways we all know. He reminds me a little bit of George H.W. Bush in the sense that I think he has run what's in many ways a competent presidency, but without the kind of vision overlay that you would want if you really want reach. For George W. Bush, he wanted to be Ronald Reagan, I think, with his values. I don't think his vision sold as well as Reagan's had. And he reminds me a little bit of Woodrow Wilson in a downside way. That is, he was, I think, a little bit too rigid, especially in the early years. He really loosened up and got better in a lot of ways in his second term. But these guys, you can see amalgams of their predecessors sometimes. It's never an exact fit, but they'll have a little bit of this one, a little bit of that one. And I invite readers to make their own club sandwiches out of these guys.
How, of course, one thing that both of them faced, but now particularly President Obama, is a context in which there's full-out political gridlock, in which there's very little cooperation of any description between the executive and legislative branches. How does that affect this exercise in constitutional interpretation from the perspective of the presidency?
What it's done, I think, for anybody who might be in the White House right now, and I think this will be true in January 2017, because I think the red-blue split is going to continue and the center doesn't seem to be anywhere to be seen. What it will mean is they're going to have to do a lot of going it alone. And the way Barack Obama is doing that is very likely the way that Mitt Romney would be doing it if he'd been elected instead. Domestic side, Obama is issuing executive orders in what I call the twilight zone. That is areas where a statute does not clearly say you may act and does not clearly say you may not. The immigration one is a good example. It's in an area where there's some authority. You have to decide whom to deport. There are 11 million undocumented people in the country, and there is money to deport 400,000 every year. Do the math. You have to figure out who you're going to deport. Obama said, we're going to keep the students and send out the felons, and we'll try to tell people that they can stay a while. This was in the twilight zone where the statutes didn't say clearly yes or clearly no. It's in the courts. I think Obama should prevail on the legality of it. But notice what he can't do is simply go to Congress and say, okay, ready now, let's do an immigration statute. We're blocked on that. And he harkens me back. I've said to some people, it looks like he got bitten by Teddy Roosevelt, because TR was completely blocked on his conservation agenda by especially the Senate. So what he did was issue executive orders in areas where statutes gave him just enough authority to do things like preserving the Grand Canyon. So it's a tradition that stretches back to presidents. Whenever Congress is not helping, they will look for areas in statutes where there's just enough room to maneuver. FDR's famous destroyers deal is one of those. There was maybe just enough authority in statutes to allow it. He was right at the edge.
So the TR comparison to Obama also seems particularly appropriate on the foreign policy side. So from what one hears about the Iran nuclear deal, one would think that executive agreements are something that Barack Obama has sort of made up on the fly, when in fact they go way back to not just to TR, but to the founding itself.
Here's one of those areas where we filled in gaps in the original Constitution. We all know that the original Constitution allows you to make treaties. President sends to Senate, and with 2/3 of a vote, you get a treaty. Starting with the Washington administration, though, we would simply make agreements with other countries. A lot of it was minor stuff. The first one had to do with how we do international mail. We had to agree with each different other nation how you do international mail. Okay, do you want to line all that up and send it to the Senate? I don't think so. You just exchange correspondence. So executive agreements started with Washington, and over the years they started being used for some important things. The destroyer deal with Great Britain was one of those. The Iranian hostage settlement in 1979 was one of those. They're often used, as Peter well knows from his work, for really delicate international things where you may have 3 or 4 international parties working. You have to schmooze it through and find a way. That's certainly true of the Iranian negotiations now. And the main constraint on it is what Congress will tolerate. I have thought this development where Congress wants a yes or no say-so on the Iranian agreement is entirely positive, because it brings Congress in. It's not something that he has any right to keep them out of. They can insist on participation, and they're doing it, but we'll get some kind of an answer right away. I like buy-in with Congress in any major foreign policy initiative, because it just makes it so much more an effort of the country.
So that points to another important check on presidential overreaches, that Congress has the tools to check the president in particular episodes and with particular practices, but it has to step to the plate and do something. Otherwise, does it tend to be a question of congressional acquiescence to particular policies and then acquiescence on the part of the people themselves?
Yes, and the hard part is knowing when you have acquiescence that you think is really genuine. Best current example, the whole set of commander-in-chief initiatives in the Middle East, fighting ISIS and so on, drones. These are matters that are being done under the authority of 2 things. One is the authorization to use force that followed 9/11 against al-Qaeda and Taliban. The other is the 2003 authorization against Iraq. Well, ISIS, for example, might be kissing cousins to al-Qaeda, but that's as close as they are. They're Mideast terrorists, of course, but we really need a renewal of authority on that. Obama has asked for that, and Congress is thinking it over in the most extended way and showing no movement on it. I think they need to get aboard and authorize something, set a limit to things, but it's difficult for them. And in many cases like that one, they will simply acquiesce in a way that doesn't make us feel very good about them and doesn't help the president much either.
So foreign affairs has historically been an area in which there's a lot of presidential interpretation, partly because the courts have been very reticent in stepping in with their own constitutional views. Has that gotten better, worse? Are there things about our current global context that tend to enable presidents and maybe even create conditions in which presidents can engage in a kind of constitutional adventurism?
I think this is very much a feature of the gridlock problem, that congressional oversight is not nearly as effective in this situation as it has been over the generations, where Congress really would engage, would provide some statutory authority or withdraw some, whatever. Now it's mostly the funding tool. And on the adventurism, we've got the whole, what I call war by machines, which is drones, cyber warfare, all these sorts of things that we really haven't thought through as a constitutional issue. Obama's been experimenting. George W. Bush experimented with these things before him. but less aggressively in many ways. And for me at least, the real concern is this. It's difficult for Congress to check the president. In the foreign affairs area we were just talking about, it's difficult for the courts to check him. For me, the real concern is this. I'm concerned about whether the presidency is out of control of the presidents themselves. That is, we have a giant secret national security bureaucracy. Part of it's privatized, part of it is CIA, NSA. The president struggles to hold command of it, and there are signs every now and again that it's slipping away. I think for one set of hands to hold fast control of this when it's hard for you and me to know what's going on is a challenge for our times. It's what I left writing this book with the greatest concern about.
And so you end the book on a hopeful note. I mean, why should we be hopeful given these conditions on the ground that seem to dilute the checks that we see in the history that you describe?
We're all we've got, okay? And the president is what we've got. And the system is working along in what seems to me an acceptably fair way most of the time. The checks work not always all that well, but as I look at the whole course of things, I think the machine is working along.
And as we start to enter into the electoral season here, is there a way that we can put your lens to work in assessing candidates for the presidency? And to what extent does the office make the person rather than the other way around?
The office will change the next president fairly immediately, very importantly. If you look back at the last, pick 'em, 5 or 10 electoral campaigns, compare them to what then were the issues of the presidency in question, the disjoint is going to be fairly considerable. What I look for, thinking about the book, is I look for those questions of personal character that I'm hoping for, a vision of the country that's clearly communicated, that it looks as though a majority of the people will endorse, the political skills to make that move along. And I'm a lot more interested in that than a position on a minor policy wonk question. It's those questions of character and value that I think have mattered the whole time and always should matter. And it is the genius of the American modern political system to obscure all that from us as well it can, at least if you live in Colorado, where it will be attack ads from here to the election because we're a purple state. So nothing but character assassination in every direction. We have to work through that to the person as best we can.
Great. Well, we have some excellent questions here from the audience, and so maybe we can move to them. So first up, we have a question. Presidential interpretation always tends to enhance presidential and federal power. Should Congress and the courts do more active controlling of this tendency? And there is an interesting trend, I think, in the Supreme Court to try to control presidential interpretation, including in the sphere of foreign affairs power. So this term we've got a case that involves the recognition power, even though you've got these precedents that go all the way back to the Washington administration, under which it's been generally understood that this is the president's power. That question is now presented before the court. And how would the court use that historical precedent in reaching its determination on the question? And should it police history in that, in a sense?
Very good question. For the court, it has been, let me start with the front of the question. Presidents certainly have an incentive to aggrandize and increase their power. this is self-interested interpretation. And the nature of the constraints in the job make presidents want to reach as much power as they can because they're so aware of the constraints that they already see around them already. So they tend to be pushing forward. As the court, as we mentioned it now, is pushing back, yes, I think especially for federalism questions, most presidents will not be unduly sensitive to that, although occasional ones are very fierce for Federalist values, Jefferson, Jackson, Reagan, and so on. So it will happen, but you need somebody with a certain conservative mind cast to do that. The Supreme Court certainly has been active in that realm, pretty much more against Congress than the executive for the most part. The Jerusalem case, the one that you mentioned, is one where they may whittle a presidential power a little. But most of the court's attempted controls to advance federalism have been by constraining the reach of federal statutes. And I'm pretty sure they'll keep doing that.
There's a very interesting case from last year's term of the Supreme Court, the Noel Canning case, in which the court addressed a question that before its decision had pretty much been addressed only through practice, that is the recess appointments. Maybe you could describe that. And the court made very interesting use of history in that decision.
It's a 5-4 decision that demonstrates that you can get anywhere you want to get with history. If you read all of the opinions, you will see that you could make a good historical case for either side. The one thing the case does, and I don't want to dwell on it over long, is to make it almost impossible for recess appointments to happen anytime in the immediate future. It is one of those cases, though, where a practice can go on for centuries without the courts ever touching it, as that had, and finally a case had just the right posture to come through.
So a question on Bill Clinton. You skipped over Bill Clinton. Anything to say about his approach to constitutional interpretation?
He's an interesting soul now, isn't he? It took him a long time to learn. My subhead on the start of his presidency is over his head. Lost a big election 2 years in, much as Obama did, for rookie mistakes, I think, in both cases. Clinton is such a natural politician that he learned the levers of power. Like Obama, his major constitutional interpretations were in foreign policy. I'm thinking of Kosovo and things like that. And both of these Democratic presidents have been quite aggressive in projection of American power, and in part for humanitarian interests, which is kind of new. That is, for the most part, presidents have projected American power to protect American citizens and American interests, and helping people like those of the former Yugoslavia just for their own sake is not something we've done a very great deal of. So that was an interesting move. I think it was forward. So he turns out to have developed down those lines.
So on that point, it's the case that both President Clinton and President Obama have been very aggressive in interpreting the War Powers Resolution to create exceptions, in effect. In both cases, they were faced with ongoing military operations that lasted for longer than 60 days without express congressional approval. Under the terms of the War Powers Resolution, they should then have terminated those operations. President Obama more recently in Libya, President Clinton with Kosovo. Any thoughts on that? And does that maybe show that there are limits on how Congress can check presidents in the context of war power and national security?
I think if I had finished writing the book last week instead of in late 2013, I might have modified some things I said about war powers. Basically, the War Powers Resolution says that if the president is using the troops in hostilities, he's got 60 days to get it done and either get the troops out or get authorization from Congress. And the book says I think that's constitutional. It's a deadline that I think Congress can do. Well, it has worked a lot of the time until Bill Clinton went over the period and Congress kind of rumbled and grumbled and eventually gave some authorization late. And Bill Clinton went over the period in Libya and nothing happened. And now with ISIS and so on, he is reaching way back to those earlier authorizations I mentioned in 2001 and 2003 to find an authority hook. And to put it in LBJ's term, it's all getting thinner than grandma's nightgown at this point. The authority is very weak. But Congress, which has asked for authority, hasn't been willing to step up and do something. It's an institutional failure for him, and it puts presidents in a very bad position.
At the same
and the
time,
country in a bad position.
At the same time that the public doesn't seem very agitated about it. Has that become, you speak of political ratification by, in effect, by the electorate. Is this, how does that play into these kinds of questions? The fact that the public seems in effect to be acquiescing to the action.
You know, most broadly, if you ask me what's the greatest change from the text of the original Constitution that presidents have initiated, it is to grab a very great deal of the war power away from what the framers surely thought was a congressional center of gravity under the power to declare war. The commander-in-chief power has come to dominate it in many ways in modern times. And that accreted slowly, and a lot of it came through late 19th century adventures in Latin America and other places. And I think Americans have become pretty used to the idea that the president will move the troops and do warlike activities without getting immediate pre-authorization from Congress. William Howard Taft may have put it best. He said, I can send in the Marines by myself, but it takes Congress to send in the Army. What he meant was, I can go do a military strike, but if I want to go occupy somebody, that's a war and Congress has to do it. There's a practical legal line there somewhere. Nobody's sure where it is, but it has moved way toward the presidency in modern years.
Right, so you can almost draw a line between real war, which requires congressional approval and for which presidents have almost always secured approval, I guess Korea being the one
Korea's
exception, as opposed to these other smaller scale operations of which there are literally hundreds by some counts, in which there's no congressional pre-approval. Does that line sort of work pretty well as by way of identifying the line in the precedent itself?
As I finished the manuscript, I thought it was working pretty well. That the difference between just a strike and a war that needs authorization lies in the nature, the scale, the expected response from an adversary and so on. There's a sense for that. Korea is the outlier. That's a precedent that failed. Harry didn't ask for prior authorization because he didn't want to constrain future presidents. But the lesson that has come down is that that was a big mistake for him, that he would have done much better if he had got Congress on board. And Dwight Eisenhower came in and said, I think Harry was over the line. I think that was unconstitutional. He had to go to Congress. So occasionally they'll take a step that has to be stepped back from. When we did the two Gulf Wars, there was prior authorization, even though both times Dick Cheney said, we don't need it.
So we obviously have a very informed audience today. We have two questions which any student of foreign relations law would pair together. One is the Truman U.S. Steel case an example of overreach on the part of presidents in interpreting the Constitution? And then another question on, can you comment on United States versus Curtiss Wright Export Corporation and its influence on the law and foreign policy in relation to presidential power? These are two favorite
Indeed.
opinions of...
Indeed. So in 1952, there's a steel strike. And Harry Truman issues an executive order that seizes the steel mills, puts them under government control. An injunction is brought against it. The injunction is successful. Harry has to give back the steel mills. The case is, I think, nothing but good for the way our government works, because those of us who work in the Justice Department know that the point of the steel seizure case is to say that when a president contravenes a statute, the courts will ordinarily stop him. It was an implied limit in a statute, but I think it was correctly decided. So the steel seizure principle is you can stretch statutory authority, but don't defy it. Don't defy the limits. That's very important within the executive branch on a day-to-day basis as presidents are advised. Yes, sir, you can go here. No, sir, don't go there. For example, the immigration order that Obama issued left out a category that he'd been considering because Justice thought there wasn't authority for it, and I think they were right. Curtis right export. Curtis right is the favorite hymn of the executive branch when it comes to extreme assertions of power, because the Supreme Court, in deciding a case that really wasn't very important, said a lot of things about how the president is, quote, the sole organ of the nation in foreign policy and has exclusive power, suggesting that Congress could not control the president. It has nothing to do with the decision of the case. It's really stupid as in terms of how the country can work well. You don't need the president running rampant. If Congress tries to control him, I think they ordinarily should be able to do so. It's hard enough for them to do that anyway. But Curtis Wright is kind of the last refuge of the scoundrel in foreign affairs dialogue. You've seen a lot of this, Peter.
Well, they have the old line is Curtis right, so I'm right.
Yes.
It's which plays out in the litigations, and all presidents will cite the case
Yes.
because it serves their interests. And one,
It's not Curtis wrong.
So some have been disappointed with President Obama to the extent that he seems to have put the Bush administration interpretations to work. Maybe a few words about the continuities between the two administrations with respect to some of these questions.
I think that was very interesting in 2009 at the start of the Obama administration. My book section on that is titled Plus ça change, the old French proverb, the more things change, the more they are the same. It shows something you see all the time, which is that presidents, once they get in office, are much more likely to be continuous than discontinuous with what predecessors have done if the actions were what the new president perceives as in the general interest of the United States. So Obama wanted to close Guantanamo, which had a terrible odor by then anyway. He did constrain further some of the interrogation techniques, which the Bush administration had already itself started to limit. But a lot of it stayed the same. Of course, the terrorists remained held over the years because it was in the interest of the United States to do that. And all the other thing is there was a question among many Democrats as Obama came in, will they be prosecuting all kinds of people who did harsh things during the terrorist years? And Obama said, let's move on. He was being very typical in that situation because he was much more interested in what he wanted to do than in making new enemies by prosecuting what had gone before. That's the way most of them are most of the time.
And so this becomes almost a way of identifying what the law is as it's evolved through presidential interpretation, to the extent that you may have excesses of one administration, you get something that comes back closer to the mean in subsequent administrations. Does that become another kind of check, is really the check of subsequent interpretation and practice?
Yes, and as you would know, many people have commented on this in the Bush-Obama situation, that right after 9/11, we had a very strong response to that. Things needed to be sorted out, and by the second Bush administration, they were much calmer about things than they had been at the start. When Obama from the other party comes in and continues a number of practices, then you've got both parties on board and a kind of a new baseline. So you're getting precedent settling over time. I think that's normal as well.
So you're somebody who served in the Office of Legal Counsel in the Department of Justice. Maybe a few words from you about how this use of, how presidential interpretation is put to work in an everyday kind of way.
The Office of Legal Counsel does legal opinions to the president on things like the immigration executive order and so on. The Iranian executive agreement has been all lawyered up in the usual ways. And what you do there is you combine normal lawyers' sources all right, let's throw in Curtis Wright. Now we're done with that. We can move on to actual things. You look at the statutory pattern, you ask where is authority and where is it denied and where's our path through. And you're very interested, as the president will be, in what prior presidents have done. And what you really like is if something like what the current president is proposing has been done before by presidents of both parties, then you're pretty happy. It doesn't look like a partisan move of some kind. It's just a presidential practice. So you're trying to hook it to the history as much as you can.
And so you end up with an opinion that looks a little bit like almost like a judicial decision, citing historical precedents and prior presidential interpretations, almost in the way that the Supreme Court would cite its own precedents.
Exactly, and if any of you have seen them, you'll notice that. The ones during the Bush administration that caused a lot of trouble, and I wrote a book about that called Bad Advice, which will show you what I thought of some of the memos, is that the memos were not balanced. That is, they did not look to see what the arguments were against what a president wanted to do. If you're in the Justice Department, you have to look at both sides because many things that the president will do will not be reviewed in any court anytime. So the president is final in those situations, and he or she has to be well advised, including where the perils are. You know, you can try this, but here's the arguments against it. And there are ways to steer presidents by saying, well, you could do this. Richard Nixon tried it. Didn't work very well. And you'll be understood on the other end of the megaphone.
Then you get, I mean, this is along the lines of an earlier observation you made. Presidents, of course, are reaching back to the greats, and President Bush did that with respect to his post 9/11 actions in citing Lincoln and what he did. Any thoughts? I mean, so it's a demonstration of this natural tendency to cite the greats, and then it also shows how history becomes a part of this picture and something that presidents look to and constrains them in their actions today.
It constrains them and it comforts them. Bush read something like 16 biographies of Lincoln, he said at one point. Obama's read a lot of this stuff. They do this, I think, because it both lets them reach back for inspiration and just gives them a sense for this terrible pressure that they're under has been shared by these other people, and they got through it somehow. Maybe I can too. So I think there's that.
Great. Well, I thought I'd close with a quotation which struck me as particularly powerful from the book, and I'd remind everybody that copies of the book will be available for signing downstairs after the session. But so this is in the context of Hal's assessment of President Polk and sort of wondering why Polk doesn't fare better in the view of history. And he has this to say: great presidents are revered for placing a moral stamp on the nation, maximizing their contribution as head of state. This achievement expands the overall legal powers of the presidency by increasing the people's regard for the office and their willingness to accept broad presidential claims of power. There's a lot to unpack there. I highly recommend the book. It's excellent reading. And please join me in thanking Harold for this very interesting discussion.
And thank all of you for coming and for your questions. Thank you, Robert.